Good afternoon, everyone. Thank you for attending today's webinar on Proposition 64, presented by Denise Bazzano and Kate Cook. We hope you enjoy this presentation and join us for the next part of this series on December 14th. A schedule of our full presentation, our Proposition 64 webinar series is available on the left side of today's presentation. A couple housekeeping items. First, all of your telephone lines are muted. If you would like to ask a question, there's a Q&A box at the top of your screen. Please type this question in the box. We have a lot of folks registered for today, so we will try to get to as many questions as possible. We are also offering CLE credit for this webinar. If you check the box on your registration form, we will email a CLE form to you early next week. We will also be sending the slides to all attendees after the presentation. Now to introduce our speakers, Denise Bazzano and Kate Cook. Denise Bazzano is a member of the Municipal and Special Districts Law Practice Groups, where she assists public entities with a broad range of legal and regulatory matters. Her experience includes reviewing policies, procedures, and contracts to ensure compliance with state and federal codes, including the California Environmental Quality Act and the Brown Act. She also has prepared and produced public records pursuant to the California Public Records Act and recently completed extensive research regarding the impact and implementation of the Control, Regulate, and Tax Adult Use of Marijuana Act. Kate Cook is a member of the Municipal and Special Districts Law and California Public Records Act practice groups. She serves as City Attorney for the City of Plymouth and Deputy City Attorney for the City of Rancho Cordova. She has excellent experience on issues related to the Public Records Act and the Brown Act, election law, and marijuana regulations. That's all for administrative matters, and I will now hand it over to Denise and Kate.
Thank you, everyone, for joining us today. This is part 2 of our 6-part series on Prop 64, which I'm sure, as you all know, is a hot topic, both in local government agencies, in business circles right now, and maybe even at your Thanksgiving dinner table, as it was at mine last week. So just one little heads up I wanted to give about Myers-Nave. We serve many public clients. We also serve private clients on issues related to marijuana. The firm's stance on this issue is one of neutrality. Our goal is to provide objective advice for our clients. And today's webinar is intended to be an educational exercise, and this is not necessarily a place where we'll be giving legal advice. We will, as Christine mentioned, be answering questions. Feel free to ask them. If we don't get to your question, we will follow up after. We're still getting to some of the questions from the last webinar. We had lots, but we will follow up in the next coming weeks over email or phone if we don't get to your particular question today. So today we'll be covering the commercial aspects of Prop 64. And the new Wild Wild West for commercial activities is the title of our program. Hopefully with, a 62-page law that we have with AUMA, hopefully it won't be that wild, but we'll see how things go over the next few years in California. So under Prop 64 commercial operations, these are the general topics we're going to be hitting today. We'll be giving you an overview of the regulatory structure that's been created under the AUMA. We'll be going over the various commercial license types. And throughout the program, we'll be comparing Prop 64 to the medical marijuana laws that currently exist in California, including the Medical Cannabis Regulation and Safety Act, which was passed in 2015. And Prop 64 was based substantially on that. It mirrors that in many ways, but there are differences that we'll be pointing out. We'll be talking about considerations for licensing agencies and what they will be considering when they give out these state licenses. When we use that term today, licensing agencies, we mean the state agencies, not local jurisdictions. And we will also be talking about considerations for local agencies to keep in mind as this policy discussion moves forward and in many local cities and counties really gets going again. This is, Prop 64 passing has really opened up this conversation again in a lot of communities, and folks are interested in revisiting their policies in some cases on marijuana regulations. And as everyone knows, we talked about last time at the webinar, under Prop 64, adults 21 and up can now smoke marijuana in certain limited locations. But does that necessarily mean that everyone who's 21 can walk into a dispensary tomorrow and purchase marijuana? No, it does not. So we're going to be talking about why that's the case today and how this is going to start to play out and the impacts it'll have on local agencies, and things for all of you to keep in mind, and things for the folks in the private industry to keep in mind too. So under Prop 64, there's a very comprehensive regulatory structure created. So, one of the main purposes and intents of the law was to get recreational marijuana production basically off the illegal market, to legitimize it, to bring it under a regulatory structure and make it safe for consumers, make it safe for minors, and do it all in a way that protects the public health and safety and raises tax money for the state. So with this in mind, the regulatory structure of Prop 64 is quite similar to that under the medical marijuana regulatory structure. The Department of Consumer Affairs is the department at the state where the Bureau of Marijuana Control is housed, and that entity, which has been renamed, by the way, under Prop 64, it was previously called the Bureau of Medical Cannabis Regulation, and now it's the Bureau of Marijuana Control. That bureau will be overseeing the implementation of Prop 64 within the Department of Consumer Affairs. The Department of Consumer Affairs will also be overseeing the development of regulations for licenses for retailers, distributors, and micro-businesses under the recreational commercial licenses. Then the Department of Food and Agriculture will be overseeing the development of regulations for commercial cultivation of recreational marijuana, very similar to the medical structure that was set up under the MCRSA last year. The Department of Food and Ag will also be tasked with creating that track and trace program, and they'll also be working with the Department of Fish and Wildlife and the Water Resources Control Board on issues that relate to water diversion and water discharge. The Department of Public Health, similar to the medical regulations, the Department of Public Health is also involved. That department will oversee the development of regulations and the issuance of licenses for the manufacturing and testing licensees. Now, when we say manufacturing, we're talking about the extraction techniques and also the edibles, that business, the food and drink business. That's going to be treated more similarly to food production in our state, and the Department of Public Health's main goal, I think, there is to make sure that all of the products are safe for consumers. And the State Board of Equalization will be collecting the taxes that are implemented under Prop 64, and then the State Controller is also going to be involved. The State Controller will be allocating the funds from all those taxes to there's lots of regulations in Prop 64 and where all the money goes. State licenses for commercial recreational marijuana businesses, similar to the medical industry, these are anticipated to begin in January of 2018. The State Bureau of Marijuana Control has indicated that they feel they'll be ready by January 1st, 2018 to issue licenses for the medical marijuana businesses. They haven't given us an update yet on the commercial. Just a note on that Bureau of Marijuana Control, the last conversation I had with someone at the Department of Consumer Affairs, they indicated to me that they'll be revamping their website soon and putting that out there in January. If anyone's gone there, there's not a lot of information there, very little actually. There's not even staff yet really in these departments to answer questions or phone calls. The department that has the most information available for folks is actually the Department of Food and Ag. But hopefully in January when they revamp the website to include all of the Prop 64 regulations and what they're going to be doing. Hopefully there'll be more information for local agencies and interested parties to get from that website. So these state licenses, there's January 2018 is when we think they'll be coming out. It is illegal under Prop 64 to operate a commercial recreational marijuana business without a state license. So in theory, these businesses should not simply just be popping up. They should be waiting in the wings right now. We do know that they're scoping out locations. They're getting funding together. But they shouldn't be opening their doors yet, because if they do, they could face some really harsh consequences, civil penalties, their products can be seized, and my guess is they would not be able to get a legitimate license locally at the state level later, so that would be a huge risk for some of these businesses to take. So there is time then for local agencies that have an interest in looking at their policies on commercial recreational marijuana businesses. There's time to have a conversation about that in your community and determine what direction you want to go. The state licenses, there's a big difference under Prop 64 when we compare it to the Medical Cannabis Regulation and Safety Act. Under MCRSA, as many of you may know, a business cannot get a state license unless they prove that they have the permission of the local entity, that they have a local permit. That's not the case under Prop 64. Under Prop 64, it puts the onus on the state agency to not issue any licenses if it would violate a local regulation or ordinance, but it does not require the business applicant to prove that they have that local permission. So this means it's going to be really important for cities and counties who do have regulations on commercial recreational marijuana to give that information to the state, to keep them updated on what their local regs are. The state licenses for the first 2 years are going to be given out as a priority to California residents and California entities who can prove that they have been in California continuously from January 1st, 2015 and prior. And there's also some anti-monopoly provisions in Prop 64. It is attempting to prevent price fixing and the giving away of free products and that type of thing. It's really, the license structure is really designed to, at least initially for the first several years, help out kind of the small and medium businesses in the state so that it does not get taken over by big business.
Now we'll go over the basic license types. Prop 64 has identified 19 specific types of licenses, but it does indicate that the licensing agencies may suggest more distinctions between the licenses. But at this point, we just have 19 specific types of licenses. Licenses are issued for 1 year and can be renewed annually. And the licenses that are issued under Prop 64 will be distinguished as non-medical licenses. The license pattern of Prop 64 kind of mirrors the license pattern under the Medical Cannabis Regulation and Safety Act, MCRSA, but there are some distinctions. I'll go over those later. But for the most part, they're very similar, and they will have to be distinguished by medical or non-medical. There are types 5A and 5B cultivation. Those are your larger cultivation commercial activities. Those licenses for non-medical will not be issued until after January 1st, 2023. So there's kind of a waiting period until the large cultivation activity can be set up. A temporary license can also be granted for a period of 12 months until January 1st, 2019. So if a business is interested in a temporary license, those can be granted as well. A license cannot be licensed, a license cannot be issued to a retailer of alcoholic beverages or tobacco, and there are restrictions on location of the activity, where the licensee will conduct his commercial activities. And we'll go over that restriction later. A licensee must also show continuous California residency from and before January 1st, 2015, as Kate mentioned. If an applicant is an entity, a business entity, the entity shall not be considered a resident if any person controlling the entity cannot demonstrate continuous California residency from and before January 1st, 2015. So the whole entity, the controlling people of the entity must show residency. There will be priority to applicants who can show operation in compliance with the Compassionate Use Act before September 1st, 2016. So if you are a licensed medical facility, like a dispensary, and you can show compliance under the CUA, you'll have priority in getting a non-medical license. That priority, though, has a sunset provision, and it will go away after December 31st, 2019. Applicants who want a license will have to provide fingerprints and other requirements by the licensing agent. So there may be other requirements that each licensing agency imposes in order to obtain a license. At this point, the Prop 64 just specifies fingerprints. Some licensees, like cultivators and manufacturers, will also have to include in their application for a license operating procedures, diagrams of the location of where the commercial activity will take place, sources of water. So if you don't have a specific source of water for your activity, then you're not going to be able to apply for a license as a cultivator. The quality, you'll also have to include in your application quality control procedures and any other information that the licensing agency deems important. The licensing authority may issue licenses to qualified applicants, but can deny an application or renewal for various reasons, including a failure to comply with Prop 64, the provisions of Prop 64. If the owners, officers, directors have been sanctioned by a licensing authority or city and county for unauthorized commercial marijuana activities or commercial medical cannabis activities, that application can also be denied. There are also statutory considerations that the licensing authority will consider in determining whether to grant or deny or renew a license, and I'll speak about those in a few minutes. As Kate mentioned, there are some significant differences between the MCRSA and Prop 64. We'll go over them throughout the presentation, but just generally, the MCRA has less prohibition on multiple licenses. The MCRSA provides that a licensee can only hold a license in up to 2 separate categories, and the combinations that are allowed under the MCRSA are fairly convoluted. Prop 64, in my opinion, is much more straightforward in what it allows each licensee to hold as far as a license goes. There's a prohibition in the in Prop 64 that provides a 600-foot radius on any licensed activity between schools, daycares, and youth centers. The MCRSA also has a 600-foot radius, but the language is a little bit different. Prop 64 specifies that a 600-foot radius applies to any activity around schools, kindergartens, daycare centers, or youth centers unless a a licensing authority or local jurisdiction specifies a different radius. It's not clear what exactly that means. It doesn't say it has to be more than 600 feet. It doesn't say it has to be less. It just says unless a licensing authority or local jurisdiction specifies a different radius. So this will probably play out to be a significant difference between the AUMA, Prop 64, and MCRSA. The AUMA Prop 64 also establishes a micro-business category as a Type 12 license. In the MCRSA, Type 12 licensees were for transporters. Microbusiness is kind of a new term, and under the language of Prop 64, it's meant to include a cultivator of less than 10,000 square feet, a distributor, a level 1 manufacturer, or a retailer. The Prop 64 also changes the Type 10 license from a dispensary to a retailer. Prop 64 also provides overconcentration language, and that a licensing authority can consider overconcentration issues in determining whether or not to grant or deny the license. The MCRSA had a dual licensing system, as Kate mentioned, and that was to protect local control in general. And the biggest distinction between the MCRSA and the AUMA is that there isn't that dual licensing system in place. So as Kate mentioned, you don't need those two licenses.
And that means with the revocation, where that comes in is a difference with the revocation of a license. Under the medical marijuana regulations enacted last year, if a state licensee loses their local license, it's kind of an automatic revocation of their state license pending, their appeal process. But that doesn't exist under AUMA, so that, the state will look at their state license to see what's going on, but it's not automatically taken away.
Now we're going to just go over generally considerations for the licensing agencies or authorities. And again, licensing agencies in this presentation refers to the state licensing agencies or authorities. And a licensing authority will consider whether it is reasonably foreseeable that issuance, denial, or renewal of the license could cause any of these considerations, which include unreasonable restraints on competition, by creation of or maintenance of an unlawful monopoly. They'll also consider excessive concentration, which I mentioned earlier. And excessive concentration under Prop 64 means that there's the ratio of licensee to population exceeds the ratio of licensees to population in the county or the city. So the city could enact a local ordinance that specifies what the ratio will be, and that would be considered by the licensing agencies when determining whether or not to issue a license. Another consideration will be to whether the license would perpetuate presence of a legal market for marijuana in and out of the state, whether the license would encourage underage use or adult abuse of marijuana or illegal diversion of marijuana in and out of the state. So the Prop 64 really tries to focus on prevention of abuse amongst youth and even adults. And so that's a consideration that would be taken into account by the licensing agency. Another consideration would be the unreasonable, would the license create an unreasonable risk of minors being exposed to marijuana, or would the license result in a violation of the environmental protection law? So
So under Prop 64, there's also many considerations for local agencies to keep in mind. You know, as I mentioned before, the passage of this law is kind of reopening this conversation in a lot of communities. And so some things that cities and counties may want to keep in mind is, you know, how did your particular jurisdiction vote on Prop 64? One city that we're working with, you know, is trying to collaborate with their county elections official to get specific data on how their city voted on Prop 64. Because as we all know, we can go to the county elections website and you can see how a county voted on Prop 64. But it would be interesting for some city leaders to know how did their constituents vote specifically on Prop 64, because it will likely vary widely, you know, depending on your community. And, you know, another thing to keep in mind with gathering public input as you have this conversation is your city interested, or city officials interested in hearing from the marijuana industry? There's a lot of members of that industry that are eager to educate public officials and residents in communities. Many of them are happy to come and give presentations about how they operate their business, how everything works, and educate as well. Education is another topic that's coming up in a lot of communities as this gets started. I was at a public meeting this week where a member of the public stood up and said, you know, I'm new to this conversation. I'm not an advocate. I'm not a member of the industry. I just live here and I want to learn. I don't know much about this, but clearly it's here, so I'd like to learn more. And she was looking to her local electeds to help her learn more about the industry and what it's going to mean for her community. And city and county staff also that we work with have you know, been going out of their way to get more educated on this industry and the benefits that it may or may not have for a particular community. There's also some regional conversations that are happening right now. Some cities and counties are talking together. You know, some are kind of out there trying to, I don't want to say corner the industry, but some are moving forward rather quickly to attract these businesses. Some communities have decided this is not for them, but there are considerations to keep in mind about your neighbors. There, you know, the state, as Denise mentioned, the state, when they hand out these licenses, must consider the overconcentration issue. So if your particular community, if, you know, one jurisdiction in your county is going to allow 10 dispensaries and another is only going to allow 1, is that going to work when the state does its math on overconcentration? So there's a benefit to working together, not just on perhaps a tax sharing conversation, which might be more complicated, but maybe just on a numbers conversation to have in the community. And another consideration for local agencies that isn't on the slide that I wanted to mention is the state also under Prop 64 is required to get information from local jurisdictions on potential applicants, kind of like a favorite list on who the local jurisdiction thinks, you know, might be a good applicant for a commercial marijuana license. So the state might be looking to your communities for input before they hand out these licenses. And one last consideration for local agencies to keep in mind as well is under the AUMA, there's this little section that's hidden kind of in the back in the revenue and tax code sections of it. But if a city or county decides to ban cultivation, either commercial or personal outdoor, which you can, or retail sales, then that local jurisdiction is no longer going to be eligible for certain grant monies that will be coming from AUMA funds. So all this, you know, revenue is expected to be raised, hundreds of millions of dollars from the excise tax that the state is going to impose, and local jurisdictions are going to be eligible for law enforcement and fire protection type grants and traffic safety things related, you know, to this topic. But if your community decides to ban the retail sales or ban cultivation of any kind, then you're no longer going to be considered eligible for those grants. So that's just one more policy consideration to keep in mind. And as Denise mentioned earlier, under Prop 64, local jurisdictions still retain a lot of control. Cities and counties may adopt and enforce local ordinances to regulate or completely prohibit the establishment or operation of one or more types of businesses related to recreational marijuana. For some cities, the answer to this question is very straightforward. They don't want these businesses within their city. For other cities, it's a big conversation. Some communities are saying, okay, yes, we're okay with dispensaries, but we don't want some of the cultivation to come here. And a lot of it also depends on how a city is set up. Does your city have, or county, have a lot of warehouse space, a lot of, available spaces that some of these commercial manufacturers or distributors are going to want to take a look at? And as these conversations on local control continue, there's a lot to consider. Because local jurisdictions have complete local control when it comes to the types of commercial businesses they want to allow or not allow with recreational marijuana, just like with medical marijuana, you can set a max number. Some cities and counties are saying, okay, we're going to allow 2 dispensaries. And we're going to allow 5 of these manufacturers. Others are saying we're just going to not limit them at all. The location, obviously, that's a very important policy discussion to have on where these businesses will locate. The types of buildings, you can develop specific standards for these uses, max square footage, setbacks from other sensitive uses, such as schools, churches, private property that may border commercial property, security plans, hours, stormwater discharge, air quality, odor control. All of these regulations can be established by a city or county. The state is going to be coming up with regulations as well, but a lot of local jurisdictions are trying to set, at least for them, what the baseline means in their community and what they need to have these operate successfully and safely. One thing that we have heard from the industry is that it can be frustrating to go into different jurisdictions and have completely different standards in one city versus another city. So as those regional conversations happen, if they do, that's one thing to keep in mind, that if the goal is to attract these businesses to a community, you might want to work with your neighbors on streamlining or cooperating on some of the regulations. When it comes to the building size limits, some communities like to limit the size, say, of dispensaries to a certain square footage. It might be something to consider when you're doing that. Perhaps don't include office space, bathroom space, educational space, so that the businesses perhaps aren't going to be completely limited by what's available in the community in terms of vacant buildings. Another huge conversation happening in communities is how do we give out a local permit for these businesses? Do we treat it under our current system that we've got for business licenses or certain use permits, or do we create a new structure? A lot of cities are creating a new system, particularly for dispensaries, where many local jurisdictions limit the size and the number. And so some are going with sort of an RFP process where applicants have a certain time period, they submit all of their qualifications and materials and business plans and security plans and operation plans, and then a committee or a planning commission or a board of supervisors or city council then determines who they want to give those licenses to. Other cities give that power to the staff to make that decision. Lots of cities that have gone with the electeds making the decisions can probably attest to the fact that those are really long meetings. Those are really long public hearings when you're making that decision on who to give your dispensary licenses to. It becomes a bit of a beauty pageant where everyone's parading their wares in front of the council and making promises about how they're going to operate and be a member of your community.
Now we're going to focus in on each of the license types. I'm going to cover cultivation licenses. As Kate mentioned earlier, regulations are being developed by the Department of Food and Agriculture for the cultivation licenses. That's being done in cooperation with several other agencies, the Department of Pesticide Regulation, which will develop standards for pesticide and maximum tolerance for pesticide use in cultivating marijuana, the Department of Fish and Wildlife, State Water Resource Control Board, and State Board of Equalization. The Department of Fish and Wildlife, the State Water Resource Control Board, and the State Board of Equalization are all working together to develop regulations that will expand the track and trace program that was outlined in the MCRSA. It's now going to cover non-medical marijuana as well as medical marijuana, and will be more, I think, technologically savvy. It's going to include electronic software that tracks seed to sales. So that's going to be very significant. And again, those regulations are still in the works, so we don't have them yet. But the track and trace program will be able to assist the licensing agencies in enforcement in determining where that seed was originated and ultimately where the plant came from, and to confirm that it was all done through the licensing system that's set up through Prop 64. As I mentioned earlier, there's going to be no large cultivation licenses for the first 5 years. There are type 1 to 4 licenses that are in the basic same amounts as the MCRSA. They range in cultivation limits between 5,000 square feet or 50 plants up to a maximum of 1 acre for a type 3 cultivation license, or 22,000 square feet limitations for type 3A and type 3B licenses. Section 19332 of the Health and Safety Code, which is referenced in the language of Prop 64, also states that the Food and Agriculture Department can limit the number of cultivation licenses issued. So this may come into play under Prop 64, licenses for non-medical cultivation. The Department of Food and Agriculture may say we're only going to issue 300 licenses for type 1 cultivation throughout the state. And if they do, then there will be limitations imposed on those types of licenses. Some local considerations for cultivation licenses. Because there are so many different types of cultivation licenses, it's important to consider what works for your community, what works for the marijuana industry. There are various cultivation licenses that you can obtain, outdoor, indoor, mixed light. The mixed light license is probably going to be very popular in the state because it fits with the California climate. There's already been a lot of interest in that particular type of license. Another consideration would be mitigation for adjacent and sensitive uses. Kate already went over that, and it is a big consideration. You have to look at the area in which the licensee will be operating to determine whether it's appropriate. Another consideration is input from the industry. What are people in the industry telling you about what will work in your community? It may not be that cultivation works in your community because of restrictions on water usage or pesticide usage or other ag uses in your area. If you have a crop that's cultivated in your community that doesn't work with marijuana because of the pesticide use for that particular type of ag, then marijuana may not work in your community. Other considerations are the environmental impact. How is it going to affect your community? And existing environmental review and regulations continue to apply. So cultivation has to be conducted in accordance with local and state laws, which would include CEQA regulations, water regulations, etc. The Bureau has indicated that they are studying potential environmental issues which would be addressed in a programmatic environmental impact report for use with CEQA. Their goal is to create a document that local jurisdictions can use to comply with CEQA. We discussed this yesterday at length, and we are not sure how that's going to be done. We would have to look at the report first, because every cultivation license has different impacts on the environment. And it's unclear how a program environmental impact report would work to achieve the CEQA guidelines, to comply with the CEQA guidelines. So we reserve the right to comment on that later. But at this point, just know that the licensing agencies are looking at a programmatic environmental impact report that potentially jurisdictions could use to comply with CEQA.
And for anyone who may not know what mixed light is, that's the type of license where a cultivator is using a combination of artificial lights and natural light. And the industry's indicated that, as Denise said, in California this is going to be a pretty popular option, and that there's some pretty impressive warehouses out there that, you know, from street level look like a regular sort of manufacturing or industrial warehouse, but then they have these retractable roofs. So the roof opens up completely to let in the sunlight and take advantage of that, use less energy, which communities appreciate environmentally, and then take advantage of all that California sunshine. So that apparently is going to be a big one. So some communities may already have, you know, a stock of buildings that are ripe for that use. The retailers and distributors. These regulations, as I mentioned previously, are being developed by the Department of Consumer Affairs. When we talk about retailers, we're talking about what we all think of now as the dispensaries, the store, the retail store. Under Prop 64, it also means the distributors. Those are the folks who move the product from one licensee to another. So perhaps from a cultivator to a tester, or from a tester to a retailer. It also includes deliveries. There's not a separate license type for delivery. Under Prop 64, a delivery business simply is considered a retailer. This category of licenses also includes the micro-business model that Denise mentioned, and that's sort of that vertical model that Prop 64 included, that seems to just be taking into account the reality of how many of these businesses operate. Some of these folks want to be a cultivator, manufacturer, and retailer all in one to keep overhead down or to control their product flow. So that micro-business is also in this category. When it comes to retailers and distributors, as we've talked a little bit about already, some of the local considerations for cities and counties to think about is location again. How do you want to limit the number of these? Do you want to completely prohibit, as you can, or allow? Do you want to allow consumption on site? Prop 64 has a specific section in Business and Professions Code, I think it's 26200, that mentions that a retailer can allow consumption on site, vaping, smoking, edibles, if the local jurisdiction is okay with it, if the local jurisdiction allows it. There's some rules about that. It has to be a separate area for folks 21 and up, and it can't be, the consumption that's happening can't be visible from any public area. And this is an interesting topic. I was just at a public meeting this week where there was a lot of time spent discussing consumption and whether a community that was considering allowing dispensaries, a few, whether those dispensaries should be allowed to have consumption on site. This is a really important thing for many in the industry. A lot of folks in the cannabis industry are very committed to education and teaching people about how to use these products, how to use them safely. And so many of these folks really want to be able to do consumption on site so that they can have a cooking class, have a gourmet edible cooking class and have the public come in and teach you, how you make these products and what's the best way to use them. If there's a topical solution that might work for someone's skin ailment, they want to be able to legally show their customers how to use the products, and they need to have that on-site consumption permission to do that. So that's going to be a big one in communities. It doesn't just necessarily mean, the Amsterdam smoking lounge model. It's kind of more than that to the industry. A lot of folks are also looking to get sort of in a niche gourmet world of wine tastings. There's also issues related to delivery services and how that impacts other retailers. If a community decides that they do want to allow some dispensaries, do you also want to allow deliveries? Cities and counties under AUMA can completely prohibit delivery in their city or county if they'd like to. You can't prohibit the pass-through transportation of the products, but you can say how many delivery companies you want, whether they can originate outside your city or county. But one thing to keep in mind, if you are going to allow the retailers, the dispensaries, deliveries do impact those businesses. So sometimes there's a balance to be found, a kind of a happy number of both that can work for the city. And that's one place where input from the market, I think, is really important. And one thing to keep in mind with the retailers and distributors also is that distributors are going to have bonding and insurance requirements, and that's also going to be established. There's going to be security and transportation requirements. Those are the folks that are going to be carrying larger amount of products than the delivery people.
I would also add that retailers can't allow consumption of alcohol or tobacco on the premises.
Right.
So that's an important thing to consider if you're going to allow retailers, that there won't be alcohol or tobacco on the premises.
Right. The law definitely tries to separate those uses. They're keeping all the vices in their own corners, I think. So under the manufacturers and testing laboratories, these licenses under the AUMA will be issued by the Department of Public Health. They're going to be establishing these regulations as well. And we've already gotten one question from the audience on this topic. Someone was asking what's the difference between a Type 6 and a Type 7 license. These are Manufacturer 1 and Manufacturer 2. The Manufacturer Type 1 is a manufacturer that does not use volatile extraction methods. So they're not using, volatile solvents that come with the danger element of potential explosion. M2 are the manufacturers that are doing the extraction with the volatile solvents. And manufacturer, when we say that's, these are the folks that are extracting and creating oils and compounds from the marijuana to be used as topicals, lotions. They go into edibles and drinks. This is a huge trend in the industry. It's going to explode in California as Prop 64 comes online with all of these businesses. And one thing to keep in mind with manufacturing, if a community is having a discussion on whether this is right, the right type of business for your community, it apparently, from my conversations with some folks in the industry in Colorado, it's really come a long way. And although manufacturing and kind of the extraction, the volatile extraction has gotten a little bit of a bad rap, there's a lot of folks in the industry who are really eager to educate policymakers on this and show them that they do this in a safe way, that they're heavily regulated by state and federal OSHA-type regs, and that there's a really safe way to do this so that it's not really that different than many other types of manufacturing uses in communities.
Delivery is also allowed under Prop 64. It can only be made by a licensed retailer or microbusiness or licensed nonprofit. The AUMA does not require that it be tied to a brick and mortar building. Under the MCRSA, that was required. That Act required that delivery be made by a dispensary, and dispensary was defined as a facility. So that provision of the MCRSA didn't carry over into Prop 64. It doesn't have to be tied to a building or a facility. Local agencies may regulate delivery or prohibit entirely, but we included this reality check. Delivery is everywhere, so consider it. Because it is, as Kate mentioned, it is going to be difficult to have retailers but not allow delivery. And also enforcement is difficult. If the vehicle that's doing the delivery isn't specifically identified as a delivery vehicle, how are you going to know that they're not carrying it for recreational use? It's just the enforcement is going to be difficult. How are you going to track the delivery? How are you going to enforce a prohibition on delivery? Oops, sorry, skipped ahead. Enforcement. So there's various administrative enforcement provisions in Prop 64. Grounds for disciplinary action include a failure to comply with the AUMA or Prop 64. Any conduct that is grounds for a denial of a license can be cause for administrative enforcement. A failure to comply with any state law. Knowing violations of local or state law regulation can bring on administrative enforcement. A failure to comply with requirement of a local ordinance regulating commercial marijuana activity. An intentional and knowing sale to minors under the age of 21 can also bring on administrative enforcement, which would include suspension or revocation of a license. The licensing authorities will be in charge of enforcing. They must give notice of a violation and a hearing, which would comply with the due process requirements of the California Constitution. Each licensing authority is allowed to enforce, but Prop 64 interestingly says that they must also have enough officers to enforce. So at this point, it's not clear how these licensing authorities are going to be able to enforce their regulations because many of them are understaffed right now. Prop 64 also sets up an appeals panel to hear an appeal of any person aggrieved by a decision of the licensing authority. And the decisions of the appeal panel can be taken up on a writ through California Code of Civil Procedure, Section 1094.5. There are also civil penalties provided by Prop 64. There can be penalties imposed of up to 3 times the amount of a license fee for each violation. At this point, we don't know what the licensing fees are going to be. But if they are significant, the penalty would be 3 times the licensing, could be up to 3 times the licensing fee. So it could amount to significant penalties very quickly, as each day of a violation is a separate violation. Their marijuana can also be destroyed pursuant to Health and Safety Code Section 11479 if civil penalties are imposed. The enforcement of Prop 64 can be delegated to local jurisdictions through a memorandum of understanding. So city attorneys or county council or the district attorney's office can pursue civil penalties if there is an MOU in place between that agency and the licensing authority. If a penalty is imposed, the enforcing city attorney or county council or district attorney can be reimbursed for the cost of bringing a civil action. Any remainder would go to the state's general fund. So if a city or county council or district attorney's office does the enforcing, they could recover the cost of the enforcement. There are also criminal penalties for unlicensed persons engaging in commercial marijuana activity. That includes violations for planting and possession for sale. It can be an infraction if they're a minor, or a misdemeanor with a fine of $500 and up to 6 months in jail and or both. If there is a conviction, there can also be felonies imposed for various violations. But I'm not going to cover that because we're running out of time.
We're going to try to cover just a couple questions right now. A few questions have come up on that section I mentioned about a city or county, losing its eligibility for grant money under AUMA for the law enforcement and fire protection grants. We've gotten a couple questions on that and how that works. So the language on that, it is actually in the Revenue and Tax Code section 34019, subsection F3, big capital C. And the language there says that the board shall not make any grants to local governments which have banned, so fully prohibited, cultivation, including personal cultivation, or retail sale of marijuana or marijuana products. So one of the questions was, well, what if we reasonably regulate outdoor cultivation? Can we still be eligible? I think on that the answer is likely going to be yes, because you haven't banned it, but it's not entirely clear, whether it's how much you have to ban to make yourselves ineligible. So that'll be interesting to see how that plays out as all of this comes online. There's also been questions about the enforcement of this, and as Denise mentioned, it's going to be interesting to see how they staff these agencies with the enforcement. We've also gotten a couple questions, too, from folks about the ability to regulate deliveries, and Prop 64, similar to the medical marijuana laws, a city and county can completely prohibit delivery to customers in their city or county. You cannot prohibit these businesses just from using your roads to pass through. And another question that keeps coming up is on cultivation. Remember, under Prop 64, a city or county may completely ban commercial cultivation. You may completely ban outdoor personal cultivation, but you may not ban indoor cultivation of up to 6 plants for personal use. You can only reasonably regulate that. That's a little off topic, but I just wanted to mention that. We've gotten a lot of questions on that. So we will look at some of these other questions. We've gotten quite a few, and we will get back to you. Thank you for joining us today. I'm going to turn it back over to Christine.
Thank you all for joining. Once again, if you check the box for CLE credit, we will email the form to you early next week. We will also email the slides to everyone that was on the presentation today, so thank you for joining. Oh, also, on this last slide is the upcoming series, all of our upcoming series for the webinar.
So on December 14th, we're going to have practitioners talking about the land use and environmental regulations and how those come into play with Prop 64. Early January, we'll have a webinar on employment issues. Then we'll be discussing taxation and ballot matters in mid-January. And then the final webinar on February 1st is going to cover the state regulations and potential changes coming down the way. So thanks again for joining us. And for those of you whose questions didn't get answered, we'll be in touch.
Thank you.